Limited and BlackBerry Limited.
My Lord, I'm happy to begin, but I understand there's a technical problem. I think the transcriber is still waiting on one piece of equipment. I don't know what that is. I don't know what the timescales are.
Well, I think we'd probably like to start.
As would I.
Good. One of the things that we're quite keen on starting for as well is that we just want to go out the timetable in this case, and whether or not you've both had any collective thoughts as to how long this is going to be. It seemed to us that there were some two tranches to the case. There's the test, if you like, which one would have thought we're obviously going to have to look at the authorities that you want us to look at, but it is slightly one way or the other. And then the other grounds, obviously, to do with effectively the rationality of the decision. And if that is right, we're rather hoping that it may all be encapsulated within the day.
I think both counsel had planned to use the full day and a half. We've agreed on an equal division of time, whatever that may be.
Yep.
Now, if I address how I propose to outline my submissions now and then come back to sort of the formal opening, as it were, there are really, although there are 7 grounds of appeal, there are 3 broad categories. There's ground 1, which is what is the test.
Yep.
Ground 2 to 6, you said, challenge to the rationality of the decision.
Yep.
Ground 7, whether the stay should have been lifted. That last ground will take me 5 minutes, if that.
All right.
I suspect the majority of the time will be spent on ground 1, what the test is. But some of those points go into the rationality of the decision grounds 2 to 6 in any event. So there is a leakage between the first two categories in any event. And I had anticipated, working on the premise of a day and a half, that I would be speaking until at 2:30 this afternoon, allowing for slight delay.
Should we see where we get to by lunchtime?
Let's see where we are, my lord.
And you'll appreciate that everybody's read the relevant decisions, so we probably don't need to go through them laboriously so far as the test is concerned.
Yeah.
All right.
Certainly.
Yeah.
Listen, I'm sure the courts, as well as reading the skeletons and the judgments,
That's grateful. You would have those.
Grounds of appeal. I don't know to what extent your lordships have looked at any of the authorities. Some of them will be familiar to you in any event.
Yep.
I see my Lord Justice Foxton nodding.
Yes. But you very helpfully sidelined all the passages in them.
Yes.
It's always much
appreciated. I hope that is of assistance. I cannot guarantee that we won't trespass beyond those sidelines, but it is hopefully a useful start. The decision itself is now reported in the weekly law report, and we put in for completeness that report in the authorities bundle. It's also mentioned in the White Book 15.11, although not in 3.4, and it appears in the February edition of the Civil Procedure News, but that really is just a summary of the relevant passages of the judgment. So we haven't put that in the authorities as such. As you will appreciate, I appear on behalf of the appellant, Optiemus, together with my learned friend, Mr. Swaroop. Our learned friends, Mr. Morrison, King's Counsel, and Mr. Chandrachud, appear for the respondent claimant, BlackBerry. This is an appeal against the order of Paul Stanley, KC, sitting as a Deputy High Court Judge, dismissing the application to strike out, lifting the stay and granting permission to amend. Permission to appeal was granted by the judge himself, highlighting the tension in the authorities as being worthy of resolution by this court. I've already said there's 3 tranches of grounds I will address your lordship on. By way of note, the last point, the lifting of the stay, logically that could and perhaps should have been the first point. It certainly was in Mr. Morrison's skeleton below. However, that's not how the judgment was delivered, and I propose to follow the structure of the judgment. So I'll begin, if I may, with ground 1. And in encapsulating this, I wish to highlight the key factual findings on abuse which the judge made and which are not subject to challenge. The court considered 5 temporal stages, very briefly, pre-issue. That's the first. Second, 2019 even, date of issue to March 2020, COVID. Thirdly, March 2020 to August 2020. Fourthly, and this is the critical one, September 20 to July 24, and that was what he held as the period of abuse. And finally, July 2024, which was BlackBerry's application to lift the stay and seek summary judgment. And that until November 25, when the hearing came on. By way of findings, I'm just going to refer to the paragraph numbers in the judgment. If you need any more guidance, please tell me. Paragraph 25, an automatic stay was imposed. There was some dispute by BlackBerry, but that was the finding. There's no appeal against it. Academic. Paragraph 54, the judge found that no steps had been taken between September 2020 to July 24. Paragraph 55, he noted that BlackBerry's explanation for this was short on detail. Paragraph 66, he said that an enforceable judgment would have been of real value. And paragraph 72, importantly, found that BlackBerry took a deliberate decision not to proceed. Paragraph 75 found that the delay was a 4-year delay. There was no explanation for the delay post-September 2020 until July 2024. Paragraph 78 held there was no objectively strong reason for a 4-year delay. Paragraph 80 found that there was a unilateral decision to do nothing, and that from September 2020 onwards that amounted to an abuse of process. Paragraph 82 found no compelling reasons had been identified by BlackBerry. And the judge recognised that accordingly, if that were the test under ground 1, then he would have been bound to strike out the claim. Turning to ground 1 itself, the legal test, Optimus's case is as follows. Is that once Grovitt-style abuse of process has been found or established, the claim is to be struck out unless compelling reasons can be shown by the claimant why it should not be struck out. We say, and we'll develop this, it should be common ground and certainly clear that prejudice to the defendant is not a necessary requirement, and it is not a question of whether a fair trial is possible or not. And BlackBerry says, sorry, Optimus even says that such an approach is consistent with precedent, principle, and the overriding objective. In particular, the approach which we commend to this court is a just and proportionate test, which reflects the position of the parties to the litigation, other court users, and the court itself. But that is the summary of the position. What I now propose to do is to take the court through the authorities. I'll take them as quickly as I can. There are a lot of them. I'm going to take them in 3 tranches. First of all, Grovitt and the cases immediately following it. Secondly, I'm going to make some overall submissions about cases which followed between then and Watford. And then lastly, look at the 3 cases, in fact 4 cases, including the decision below, Watford, Lloyd, SNV, and the decision under appeal. Turning to Grovitt, this is in the authorities bundle, tab 24. It's a short but important judgment. In essence, the court held that once abuse is found, I quote from page 199, if justice so requires, which will frequently be the case, this is the sideline bit at the bottom of the page, number 8, letter H, the courts will dismiss the action. Now, Grovitt created a new category of abuse that was different from Burkitt and James, where prejudice is not required, and that was critical. And this should be common ground and is apparent from the authorities. Burkitt and James' second principle was based on inordinate and excusable delay, leading to substantial risk that it was not possible to have a fair trial or serious prejudice. Accordingly, a case would not be struck out under Burkitt or James if there were no serious prejudice. Grovitt was a conscious decision by the House of Lords to expand the inherent jurisdiction. Where intention is at issue, Lord Wolfe says that there can be an abusive process irrespective of whether prejudice is a factor. Now, This is part of the inherent jurisdiction. In terms of what Lord Wolf's test was, we see that at page 199 of the bundle, the sideline passage. And again, if convenient, I will give authority bundle page numbers as opposed to internal page numbers.
Sorry to interrupt. Could you pull that microphone over towards so you're speaking into it?
Certainly. There's a slight height differential, but I'll do the best I can. In the passage I'd like the court to look at, which I'm sure you have already, is that sideline between G to H.
Yep.
It's just below G, to commence and to continue litigation which you have no intention to bring to conclusion can amount to an abuse of process. Can amount is important. Where this is the situation, the party against whom the proceeding is brought is entitled to apply to have the action struck out. And if justice so requires, which will frequently be the case, the courts will dismiss the action. So that was the test identified by Lord Wolf. Raises the question, what does which will frequently be the case signify? And we say, in contrary to the way it's been interpreted in subsequent cases, this is more than a casual observation. We say that this is, at the very least, an observation of the application of the test. The test is such that only a few cases will survive an application to strike out once abuse has been established. We say with respect that Mr. Justice Richards was right in the Watford case to call this a proposition. And as we shall see, the authorities show that justice does infrequently, if not invariably, require the claim to be struck out, irrespective of question of prejudice and whether a fair trial is possible or not. Now, the two cases which followed Grovit are the Board of Governors of the National Heart and Chest Hospital in Chettle, which follows it in Authorities Bundle. I'm going to take you, if I may, directly to Arbuthnot at tab 26. It's slightly counter-chronological, but this is also a decision of Lord Wolf, so I'd like to take them together, if I may. And Arbuthnot expanded the scope of Grovit-style abuse. And if I can take you to I'll take you to various parts of it because it's important, because it feeds into other submissions I will make. So starting at Authority Bundle page 215 at the top, just above the first punch hole, Lord Wolf said that these two cases also provide a convenient opportunity for this court to give some guidance to the assistance of the profession as to the likely consequences in the future of excessive delay in the conduct of legal proceedings, now that the courts are in the process of implementing changes requiring the parties to conduct their litigation with reasonable expedition. In other words, he had the advent of the CPR well in mind, and one of the issues will be that to the extent to which Grovit and certainly the Board of Governors Chettle case survive the coming into effect of the CPR. I'll come back to that in due course. Delay here of 5 years, I'm going to turn you straight to Authority Bundle page 222 and the sideline passages. Again at the top, reference to speech of Lord Griffiths identifying civil procedure processes which were being introduced. Echoes what I've just said. And at the bottom of the page, the double sideline passage, while an abuse of process can be within the first category identified in the it is also a separate ground for striking out or staying in action, which does not depend on the need to show prejudice to the defendant or that a fair trial is no longer possible. The more ready recognition of wholesale failure as such to comply with the rules justifies an action being struck out, as long as it is just to do so, will avoid much time and expense being incurred in investigation. It should be investigating questions of prejudice and allow the striking out of actions whether or not the limitation period has expired. The question whether a fresh action can be commenced will then be a matter for the discretion of the court when considering any application to strike out that action, and any excuse given for the misconduct of previous action. And 2 lines down, in exercising discretion to whether to strike out the second action, that court should start with the assumption that if the parties had one action struck out for abuse of process some special reason has to be identified to justify a second action being allowed to proceed. And there's quite a lot in that passage which we rely on. There's the advent of the CPR, the regard to other matters, the importance of compliance, the absence of prejudice, and effectively a presumption of striking out. Now, this was a development to Grovitt in the sense that you didn't have to start, make quite clear, you didn't have to start off with an intention not to proceed a case to resolution. A claimant could start the case in good faith, intending to proceed to trial, but change tack halfway through. That nonetheless would engage the Grovitt principles. It's also quite clear, and this should be self-evident, that the relevant intention not to proceed with the case need not persist at the time of the application, whether to strike out or lift the stay. That's made clear in a subsequent case called Solland, but I just flag that at this point. It's a self-evident proposition. So it doesn't matter that subsequently a claimant changed their mind, decide to get their act in order. If there has been abuse, that abuse can engage this principle. We then move back to the
Can I just ask about that passage you took us to at 222. Lord Wolfe is talking about long delay in these cases, but he actually puts it in that passage in terms of a wholesale failure to comply with the rules. And so he seems to see the two things as closely connected. Is that right?
Well, in that case, I think the delay was approximately 5 years, so there was an abuse in terms of a delay rather than simply non-compliance with the rules. There may be cases where there is overlap, but he really is looking at, we say, the Grovitt-style abuse case, where it is the delay, it's the non-prosecution, which is a problematic situation.
But there can, as you say, there can obviously be a high degree of overlap between the two things, because it might at least implicitly be said that, even if it's not quite spelt out, that the rules, indeed you rely on a rule, I think it's 1.3, is it? Which says that the parties have to assist the court in furthering the overriding objective. It could be said, I suppose, that if there's a long delay, then the party is breaching that rule. And it seems as though that's the way, here in this passage at least, that Lord Wolfe is looking at it.
Yes, and I think perhaps he's looking at the sense of the rules being the requirement to progress a matter expeditiously.
In a general sense.
Yes, rather than any specific rule under the rules of the Supreme Court or the CPR has subsequently happened. Now I wish to move back a tab to tab 25. This is what subsequent authorities tended to agree to the Chess Hospital case, although the judge below referred it to Chettle. This is an important case. It was a possession claim, and BlackBerry accused my client in their skeleton of misreading the decision. We say the opposite is true, but it does require one to understand properly what Lord Justice Aldous was saying in this case. And in short, Optimus's position is as follows. It says that Chest Hospital laid down a test which the Court of Appeal applied to the facts of that test. That test is one of compelling reasons. In other words, once abuse has been established, the onus is on the claimant to show that there are compelling reasons why the matter should not be struck out. Now, the application of that test was important in the case. Interestingly, perhaps touching the point my Lord Justice Miles just made, that case refers to the inherent jurisdiction to dismiss an action, and one sees through the cases, some of these cases are dealt with explicitly under 3.42b, some are dealt with as inherent jurisdiction, some of the cases say it probably doesn't matter that much which way one looks at it. Importantly though, they're not 3.42c cases. We'll come on to the contents of that in due course. In this case, at first instance, the judge found that there was prejudice by reason of the delay. The Court of Appeal reversed that, and one can see that pages 209 to 210 of the authority bundle. Very bottom, justice orders the sideline bit. In the present case, the evidence does not establish more than the ordinary anxiety that accompanies litigation, even though this is an action for possession. That anxiety is not, in my view, sufficient to justify striking out the action for want of prosecution. As the anxiety caused by the inquiry agents was not caused by the delay in prosecuting the action, therefore is not relevant. The prejudice said to have been caused by reluctance to repair and redecorate cannot be assessed by relying on a one-sided balance. So no prejudice, no relevant prejudice there. And you see that at the sideline bit, the next paragraph, top 210, the grounds relied upon by Mr. Chettle to establish his prejudice are not sufficient. Not suggest the case is one where the witness's recollections have deteriorated. No doubt Mr. Chettle has suffered the normal anxiety of an action for possession and suffered disturbance by the difficulty of living without serious repairs and redecoration taking place. But then it also moves on to Grobbett and Doctor, one sees at the beginning of the next paragraph. And that's important, that no prejudice was found. The relevant passages are on the next page, indeed the final page of the judgment. This is a long section and it will speed up time if I invite the court to read from the top of the new paragraph, as was stated in Ashmore, down to the end, and then I'll make my submission. At least two aspects of that. First of all, it's the fact that towards the top it says that such proceedings will normally be struck out as being an abusive process. And then at the end, it says once the action came to amount to an abuse of the process of the court, it required to be struck out unless compelling reasons to the contrary could be demonstrated. There are no such reasons in this case. Now, the subsequent authorities are divided as to whether that is a test or specific to that case. And I say that it is a test. The wording might have been clearer, I acknowledge that. But even if he's talking about this case, what his lordship is saying is that once abuse has been established, the correct approach is to strike out the case unless there are compelling reasons.
I mean, do you say that you say it's a test? I want to work out. Is it a test for Grobbett abuse?
Yes.
Is it a test for all abuse?
It's a test for Grobbett abuse. Test for Grobbett abuse. It's clearly part of his self-direction. Given the finding of the taking user that there was no prejudice, it's potentially, if not critical. Had it been an interest of justice approach, it's difficult to see that the court would have struck out the claim given the findings. Certainly the judge would have to explain why the absence of prejudice did not militate against a strikeout. Now, as to the word normally, that has echoes of what Lord Wolfe said frequently. But if anything, it's stronger. And again, it suggests a default position. This is the default, absent something else. What are the absent something else compelling reasons why not to strike out a claim? One final small point, which shouldn't detain this court long. It's a two-judge court of appeal. The judge below describes it as a two-judge court of appeal. If that is simply a description of the composition of the court, that is undoubtedly correct. If there is some suggestion that it has lesser precedent value as a consequence, I would respectfully differ. No point is taken on that, and I'll say no more about that. Next case is tab 27 of the bundle, Vitaro and Vitero Foods. It's an unfair prejudice petition, petition Mr. Justice Lindsay. Another case where the matter was struck out. One gets an essence from the top of page 225. This is from the head note, and I'll take you to the key passage. In this case, the gap was at least of 3 years. Bottom page 229 of the authorities bundle. Reference to what was then the unreported case of National Heart and Chest Hospital in Chettle, from which Justice Lindsay quotes at length at page 230 of the bundle. At the bottom, between G and H, he moves on to his analysis of it. It is to be noted from that long quotation. It can be enough to amount to an abuse to this character of the proceedings, albeit started with a view to being taken to a conclusion, become later moribund. In other words, once started, not maintained for that purpose. It is not a necessary feature of abuse of this kind that proceedings even have to be started with a view to not being proceeded with. Secondly, once such abuse is shown, it appears in the case that is for the plaintiff to bring forward compelling reasons to the contrary, if striking out is to be avoided. Thirdly, the strikeout in this ground may proceed notwithstanding that a relevant limitation period has not expired.
Sorry to interrupt, sir. Can you try and keep the mic?
I'm so sorry.
Thank you.
So I say up to this point, in the late 1990s, the position was clear and the test was one of compelling reasons. Move on to the next strand of my submission, which is whether the pre-CPR cases survived the introduction of the CPR in April 1999. Now, self-evidently, lots of pre-CPR procedural cases remain relevant. Burkitt and James and Grovett amongst them. Effectively, what BlackBerry is saying in this case is that while Burkitt and James and Grovett and maybe Arbuthnot remain relevant cases, Chest Hospital has not survived the passage of time and the coming into effect of the civil procedure rules. Now, the civil procedure rules have, if anything, increased the importance of compliance with rules, and one can see that from a number of cases and commentary in the White Book. It's been said, and this is in the passage of the White Book in Authority 5, page 43 of the bundle. I'll take you to that very briefly, although it'll be well known to the court. Just above the top punch hole, page 43 of the bundle, this is the commentary in the White Book. You see 25 of yes, Lord Justice Hurt explains the courts today apply an approach to case management in general which is less tolerant of delays than before. I say that's relevant. It undermines the suggestion that the coming into force of the civil procedure rules have given greater latitude to non-compliance and to delay. As has been said, the courts exist to enable parties to have their disputes resolved. Robert itself noted that the court should more readily make unless orders than had hitherto been the case. Even CPR Rule 15.11, the automatic stay, the clear purpose of that was to avoid the existence of claims which are not being progressed. And I refer to the judgment be well known to one member of the court in Bank of America. And one can see other passages stressing the importance of making sure that the court's response to abuse of powers do not have their teeth drawn from them. That's a paraphrase and a bad one from Honourable Judge Kaiser in Lloyd. But perhaps I can take you to one of the most recent cases, SNV. This is tab 46 of the authority bundle. Your Honour Judge Kenneth Kelly. I'll come back to this later on, I just want to highlight one very short bit that's appeared in written arguments, page 682 of the bundle, the last 3 lines of the sideline passage, paragraph 69 of the judgment. In short, a modern approach to case management under the CPR is the antithesis of endorsing abuse of process.
Sorry, which page was that?
Page 682, it's SMB is the case.
Got it.
Page 682 of the bundle.
Yep.
Paragraph 69, last 3 lines, the sideline passage. So I say that the coming into force of the civil procedure rules is no reason for any of the cases, including Chest Hospital, to cease to have the precedent and the force they once had. Now, there are a number of cases in the authorities bundle following Vitera up into Watford. I don't have time to go through all of them, but I'll make a few overall submissions now. As far as we can tell, in all the cases where abuse has been established, the court has struck out the claim. Now, it's very difficult in things like this to prove a negative, but certainly the cases we have looked at, the cases which appear in the bundle, that is the invariable outcome of a case where abuse is found. The only exception is the judgment under appeal. Obviously, the periods of abuse vary from case to case, and each case needs to be looked at its own circumstances. Sometimes the passage of time is very considerable, but the nearly 4 years in the instant case is among the most serious. Conversely, there are some cases in which no abuse was found, and those cases tend to be shorter period of delay, and I'll give some examples in a moment. And secondly, because no abuse was found, what they do say about the response is obiter. And those cases are the minority in the bundle, and there are really 4 of them, apart from the decision under appeal. First of all, a case called Quadritigini, apologies for the pronunciation. That was a delay period of about 18 months. It's tab 37 of the authority bundle. That no abuse was found, and it made some comments adverse to my client's position as to what will normally happen. And I say they are obiter and really do not reflect the reality of the case law as has transpired. Now, so I can take you through it very quickly. Tab 37. The Deputy Judge there, Third Master QC, overturned the decision of the Deputy Master, striking out the matter, finding there was no abuse. And he says, Third Marshal QC, says it's a relatively rare case where the matter will be struck out. And I say that simply isn't.
Where is that? That's
Sorry, bear with me for a second to find the reference.
It's page 448.
17. Goes up the paragraph number.
17. I'm in the wrong, it doesn't help, I'm in the wrong authority. Yes, paragraph 17, bottom page 448, I'm grateful. The judge says it will be a relatively rare case in which the court will strike out proceedings to review the process based on delay in the first instance. As an empirical observation in respect, that is wrong, given all the other cases in the bundle where abuse has invariably led to a strikeout.
well, we've got someone
Yes.
saying it will happen frequently and someone saying it will be relatively rare.
Yes.
Those sound like predictive statements.
One has to test to see whether they are.
Well, how can you do that?
Yeah, well, exactly. I mean, I could go through all the cases, but unfortunately, especially if the court is keen to resolve the matter today, I do not have the time to do so.
Well, we're not going to get into a
No.
mathematical
No,
exercise.
and clearly I'm not suggesting that that is the outcome to this, or that matters turn on the simple length of the delay. But I do say it is an important proposition that abuse has invariably led to strikeout in the cases.
Can I just ask about
Yes.
what in this decision the judge referred at some length to the Biguzzi case,
Yes.
which was I think a breach of rules case
Yes.
strictly, but in the passage which he cites at paragraph 14, Lord Wolfe talked about excessive delay and drew attention to the Burkitt and James approach, but then went on to talk about the what he calls a more well, he refers then to the overriding objective, talks about the general culture, but I think in this case also talks about the approach of the court to strikeout. So on the passage at 447, a few paragraphs down, he says the advantage of the CPR over the previous rules is that the court's powers are much broader than they were. In many cases, there'll be alternatives which enable the case to be dealt with justly without taking the draconian step of striking the case out. And there he seems to be talking about striking out for abuse of process. And as I say, it draws attention to the broader powers under the CPR. Do you have a submission to make about that case and what use was made of it by the judge in the case we're just looking at?
When you say that case, you mean Biguzzi?
Yeah.
Well, so Biguzzi is obviously a post-CPR case. First cases to lay down the new regime. Was a breach of the rules case, in contrast to what we are concerned with. Even in the passage my Lord has just referred to, the top of page 447, under the CPR, the keeping of time limits laid down by the CPR or by the court itself is in fact more important than it was. Now, in terms of the broader range of powers which the court has, this can cut both ways. It explains partly why cases such as Burkitt and James were difficult to succeed on under the tests in that case. But it clearly allows for the fact that in some cases it will be appropriate to make an order other than strikeout. It depends upon the facts of the case. In a case which is a relatively small delay as this was, where he found there was no abuse, it's very difficult to see how logically a court can say, well, I don't find there was abuse, but if I'm wrong nonetheless, that would have entitled, would enable me, empowered me to strike out. The second just simply cannot logically follow from the first. So I say, in relation to what one takes from litigation, I say, first of all, it is respect not on all fours with all the other cases between Vitara and them. The prediction that it will be relatively rare that a court will strike out again is contrary to what they say, ignores the test of normally and frequently, doesn't refer to some of the cases we've just looked at, certainly doesn't refer to the test hospital, does refer to Grovit, doesn't refer to Vitara. And what he's saying in terms of the response to the test is overture for the simple reason that no abuse was found. In terms of the other cases, I'll deal with Alibraham and Asturian because it's an important case, but it's almost exclusively about stage one, which isn't troubling this court, namely how does one establish whether abuse has suffered or not. That's tab 38, authorities bundle. Now, I'll take this as quickly as we can. Deputy Master, I think, struck out the matter. The judge allowed the appeals and no strikeout, and the Court of Appeal agreed with the judge. But save for the final paragraph, the entire focus of that case, Asturian and Alibraham, is on stage one. And it's the first case to recognise that, strictly speaking, there are two stages. One, is there abuse? Two, if so, what is the court's response? And it says that a two-stage test better echoes the wording of the rules as opposed to a three-stage test which had been argued before them. But because all of that is on stage 1, we get to page 466 of the bundle, paragraph 78. Was the judge entitled to conclude that student's conduct was not an abusive process? Finding there was no abusive process. Paragraph 79, which has been cited subsequently, is the only paragraph dealing with stage 2, in other words, the response. But even if the judge was wrong to conclude that student's conduct was not an abusive process, the question remains as to whether he was entitled to exercise his discretion not to strike out the claim. The judge held that even if there was an abuse, it was a relatively minor nature and did not justify the sanction of striking him. In my judgment, the judge was fully entitled to take that view. Although neither the master nor the judge gave any detailed consideration to alternatives to striking out, there were lesser sanctions available to the court, which were more proportionate to the abuse, if abuse there had been. For example, the court could have imposed time directions to trial, including unlessing orders, and it could have imposed a cost sanction. Striking out was a disproportionate response. That's all it says about the stage 2. I suggest that this is very little assistance to this court. The most recent case where no abuse was found was Lloyd and Hayward, but I'll come to that shortly. The next case I wish to take the court to is the case of Watford Control Instruments. This is tab 43 of the authorities bundle. Appeal against the decision of Master Pester. And this case is important because Chest Hospital is relied upon. And Mr. Justice Richard says that the compelling reasons is the test to apply to stage 2 of the inquiry, namely what is the response to abuse. I'll take the court through the judgment as quickly as I can. So you'll note at page 583, no challenge the judge's finding that it was engaged in grovet abuse. So the question of response becomes a live one. Page 584. Makes in paragraph 23 and 24 makes the point that grovet was a deliberate and conscious extension of the law for the reasons I previously said. Paragraph 25, Justice Richard says the existence of that intention alone, the abuse of intention, can therefore in principle be sufficient to constitute the abuse irrespective of whether the defendant has suffered any prejudice. Then over the page from 586, paragraph 33 of the judgment, Justice Richards, following through Hospital, makes the point that he went further, that the Lord Justice Aldous went further in saying grovet abuse would normally be struck out. And he quotes from the judgment there, and we've already seen that passage concluding at the bottom of page 33, sorry, paragraph 33 of the judgment in question. Paragraphs 34 to 35, I add the emphasis to the passage to bring out what Mr. Brown submits as a statement of principle binding on this court and on the judge. Now, it wasn't argued before Mr. Justice Richards that as to whether Lord Justice Aldous was expressing an evaluation or not. The claimant didn't suggest that he was only expressing an evaluation on the facts of the case before him. Accordingly, I take the claimant to accept that the highlighted passage is capable of amounting to a binding statement of principle, though it does not accept that it actually does so. And then there's various arguments as to whether the statement of principle is binding, so it was inconsistent with the speech of Lord Wolfram Grovet. And Mr. Justice Richards concludes, bottom paragraph 36, that is guidance as to the proper interpretation of Grovet, which is binding on this court. Next, the claimant argues that Chest Hospital has scarcely been cited since, and that the principle that I quoted has been diluted in subsequent cases. True it is that it had only been cited in Vitara and not since Vitara until Watford, but nonetheless it's Court of Appeal authority. As to whether there was any dilution, over the page 588, Mr. Justice Richards concludes, well, says that he's quite unable to accept that the passage involves any dilution of the principle that Lord Justice orders formulating Chest Hospital. Passages say obiter, as the claimant accepts, it's dealing with the position on the hypothesis, contrary to Lord Justice Arnold's conclusion that Steering was guilty of Robert abuse. Then he develops that in paragraph 40. You can see there, the 4 lines down, entirely consistent with the proposition that where a claimant is engaged in Robert abuse, the claim will be struck out absent compelling reasons. Lord Justice Arnold simply expressing the opposite view, that since any abuse was minor in nature, the necessary compelling reasons were present in the case before him. And then Justice Richards continues on page 589. You can see the various highlighted points. The thrust of all that is at 45. In my judgment, civil procedure rules did not throw overboard the judgment in either Grover or in Chest Hospital. Both before and after CPR, the court had power to strike out a claim that involved an abusive process, with the post-CPR power being found in Rule 3.42b. At its heart, Grover simply expanded the category of claims or behaviour that involved abuse. On to paragraph 46. I'm reinforced in that conclusion by the fact that the Court of Appeal has already considered the role of Robert abuse in the post-CPR world in Arbuthnot. We've looked at before. And then his conclusion, paragraph 47, the proposition in Chest Hospital that compelling reasons are needed to prevent a claim involving Robert abuse from being struck out remains good law. He goes on to acknowledge the importance of proportionality and stresses the proportionality of any sanction. Chest Hospital does not cut across that, but rather decides that in cases of Robert abuse, strikeout would be a proportionate sanction unless compelling reasons to the contrary are shown. After all, 2 obvious points that might be made in objection to strikeout in case of Robert abuse are that the defendant suffered no prejudice and a fair trial remains possible. However, as Grovet itself stresses, the abuse can still be present in these cases. For me to expand the reasons that Lord Justice Aldous gave in Chest Hospital, I respectfully consider the approach of requiring compelling reasons to enable the defendant to resist strikeout is consistent with the nature of the abuse identified in Grovet. And then, with that benefit goes on to whether the judge applied the correct test, whether the master applied the correct test. Paragraph 49. 3 lines at the bottom. However, as Chest Hospital demonstrates, having found that there was Grovet abuse, the judge should have proceeded from the starting point. The claim would be struck out unless compelling reasons could be shown for a different course. Then he goes on, paragraph 51 and following, to re-exercise discretion. Well, that obviously is specific to its circumstances. A couple of points which to draw out. Page 591, paragraph 57. This is relevant to whether the defendant's misconduct, or whether the defendant has been remiss, is a relevant factor in the inquiry. And it's the last 6 lines of paragraph 57 of the judgment. However, the present case is concerned with the claimant forming an objectionable unilateral subjective intention to put the proceedings on hold for a substantial period without any good reason. Mr. Brown, as the defendant in this case, had no control over whether the claimant formed that intention. There was not any upcoming case management milestone which Mr. Brown was obliged to help him achieve. The principles set out in Asian Sky Television are not engaged. Very briefly, Asian Sky recognises the fact that, contrary to the position of Burkitt and James, it's no longer appropriate to let sleeping dogs lie in the defendant. That's true in 3.42c cases, but what Mr. Justice Richards is saying here, and as part of my client's case, is that that principle is not applicable to an abuse of process case, when the whole focus is the claimant's unilateral decision, internal decision-making process. It's difficult to see.
A recurrent theme, I think, of your
Yes.
submissions is this sharp divide between 3.42b and 3.42c cases. And submissions appear to proceed upon the basis that abuse of process is entirely encompassed within B. Now, I presume we will at some point come to the rules on the White Book, but you can breach a court order or practice direction abusively.
Yes.
And at least the commentary in the White Book suggests that 3.42b is where the statement of case itself is the abuse because it's re-litigation,
Yes.
or it's hopelessly vague, or
Yeah.
the game's not worth the candle.
Yeah.
And that other abuses are dealt with under 3.42c.
Yeah.
So I just wonder whether there really is this sharp divide between those two categories.
But can I take that in stages?
Yeah.
First of all, as to whether this is really something for the inherent jurisdiction of 3.42b, I've touched on that before. And the White Book itself says when one is dealing with the abusive conduct of the case, it's slightly inapt to say that the claim itself is abusive. It's the conduct of the claim. But nonetheless, frequently the cases are treated as being under 3.42b.
That they have without
Yes.
anyone ever
No, and I said that's not an answer to your
properly
lordship's
embraces
question.
that.
No, that's and it sets it up. As to whether there is a distinction, I would say, well, there may be overlap. In some cases, may involve the breach of both the rule and be abusive conduct. Nonetheless, there is a conceptual difference between abusive conduct or non-conduct, as it invariably will be. As per the facts of this case, nothing is done from September 2020 to July 2024. While that involves, from one level, the non-compliance of a rule, it is, I suggest, qualitatively different from other cases where there's been a clear non-compliance with an order to disclose documents or do something else, take another step in the litigation.
But isn't it all dependent on the facts? I mean, take a case where where the non-compliance with the disclosure obligation is total, to the extent that a fair trial just isn't possible. That's been held in some cases to an amount to an abusive process which justifies striking out the claim. That might be considered to be quite a bit worse than some cases where there's been a delay coupled with an intention not to get on with it. In other words, doesn't it all depend on the facts?
It does, and one other aspect of this is that there's a debate as to whether there is a proper division between the never cases and the maybe cases. And some of the authorities do establish that you can intend to, from the start, you intend never to proceed to trial. That's the most egregious example. The other ones, you start off in good faith and then you change, decide you're not going to do anything about it. Or the third case, the maybe one, well, we're not doing anything unless a contingency arises, such as new disclosure comes up or a witness makes themselves available, something like that. Now, while the first one is more egregious than the others, in my submission, the distinguishing between the three runs the risk of ignoring that each case is relevant on its own.
That's slightly different.
It is a slightly different
Point with respect.
Yes.
That's, I understand that.
Yes.
It's a separate argument, but the question I'm asking is a different one, which is where there's a clear obligation under the rules, for example, to give disclosure. Instead of doing that, the party destroys all its documents, say.
Yes.
That would, on I think most people's view, amount to an abuse of the process of the court. It's a breach of a rule, and if you were to apply to strike it out, you'd do it under little c. Or is it little b? I can't remember.
C, I
C is the rules. Yeah.
C is the rules. There, we've been told by Asian Sky that there's a whole range of possible outcomes, and that the court has to apply a sort of proportionality analysis and take account of the draconian nature of the striking out. Now, it might be thought that it's a bit odd to have a separate set of rules for abusive delay just because it's a delay. I mean, why would that be a rational or coherent set of principles?
Number of reasons. First of all, as I said, Grover was, to paraphrase Mr. Justice Richard, a deliberate and a conscious extension of what was abusive conduct under the inherent jurisdiction of the court. To get round the fact that Burkett and James, the principles there, were very difficult to succeed under, absent clear prejudice. But recognising that one of the categories which existed was very rarely going to come to the assistance of the innocent party in a claim. true it is that in some cases the innocent party, or the defendant, whichever party it will be, will run a number of arguments, whether it's under inherent jurisdiction 3.42b, 3.42c. To take my Lord's example of disclosure being deliberately destroyed, one looks at the principle of letting sleeping dogs lie. It's difficult to see what the innocent party in that case can do in response to that. There's nothing it can do to get the matter back on track if disclosure has properly been destroyed. So one can see the most natural way of analysing that is by way of an abuse of process, even though the direction to disclose has not been complied with.
What we tend to do in those is use adverse inferences
Well,
to achieve the fair trial that remains possible, don't you? I mean, the cases where people deliberately don't produce disclosure don't generally lead to strike out absent compelling reasons, or at least I've never seen that.
well, it might depend on what's been done, but if that were coupled with other things, the court might reach the conclusion that the non-disclosure was one aspect of an overall abuse of process.
But many people might think that kind of case was worse than a case of delay.
They might be, but I'm not endorsing the outcome in the facts that your lordship has given to me. He was saying that that case nonetheless survives. If there has been that abusive destruction of documents to such an extent that the nature of the case is such that has a huge impact upon the matter, one could see why that would lead to the conclusion it's appropriate to strike out.
Just on the other point that Lord Justice Foxton asked you, do you, because it might be helpful to understand it, is it your submission that this kind of abuse is really part of the inherent jurisdiction of the court rather than coming under 3.4, or do you not have a submission on that?
No, I do, and I acknowledge that if one looks at the application notice in this case, it was squarely made under 3.42b. It seems to me, my submission is that it more naturally recognised as part of the inherent jurisdiction of the court, which survives the coming into force of the CPR, as explained by the cases including Watford, which we just looked at. As it happens, that concludes my submissions on Watford. I'm grateful for the questions. We move on to the next case. I think the transcriber would be grateful for break. It's probably a bit too soon at the moment, but I'm entirely in court's hands.
The practice of this court, as I understand it, is not to give transcribed breaks.
Oh, well. I'm in no position to countermand that, so I shan't. Move on to the next case, case of Lloyd and Hayward. That's tab 44. In this case, His Honour Judge Kaiser held or did not find that there was abuse. So what he says, and there's quite a lot of it, is his obiter as to the test. A lot of the cases were cited to him. He looks at matters, he looks at Watford, and he reaches different views. I'll take you through them as quickly as I can. He also refers to Asian Sky, the principle we were just talking about. We start at page 619. We draw certain points from Assyrian Al-Ibrahim, which is on really stage 1. And we can just really note that without inquiring in it very closely. Paragraph 625, you'll see that reliance was placed on the decision of Mr. Justice Richards in Watford, that's paragraph 65 at the bottom page. And in the subsequent pages, 66, 67, 68, quotation from Mr. Justice Richards' decision. We then get on to page 69 of the bundle, paragraph 66. His Honour Judge Kaiser disagreed with Mr. Justice Richards' reasoning. He thought it was out of step with other post-CPR cases, and he explains his reasons. And they're numbered subsequent pages. arise. One, if justice so requires. Two, he says the statement in the Chest Hospital case, referring to unless compelling reasons to the contrary could be demonstrated, is by no means necessarily inconsistent with Grove and Doctor, but it introduces a gloss that goes further than anything said in that case. And then paragraphs 4 and 5, we can skip over 3, again dealing with Chest Hospital. Paragraph 5 says that Chest Hospital cannot be binding precedent because it's decided before the existence, let alone the coming into force of the CPR. If that were true, Burkett and James and Grobert and Arbuthnot would not be authorities either. And then deals with the fact that Justice Arnold's comments in paragraph 79 in steering were obiter, which they clearly were. Then point 7 deals with Asian Sky, 3.42. Here there's a typo. It says Asian Sky concerns strikeouts under 3.42C, breach of an order, rather than under 3.42C. It must mean B on the second line, use of process. Because it may be that strikeout more commonly be the response to abuse of process than to the breach of an order. Does not mean that ought to be any basic difference of approach into situations. That is contrary to the argument I'm putting before this court. And then we lead to the conclusion of paragraph 68, bottom page 61 of the bundle, where Judge Kayser respectively thought Ms. Justice Richards was correct to be concerned at the possibility that the approach to the exercise of discretion under the CPR might be misunderstood to have drawn the teeth from the court's response to abuse of process. Moreover, abuse is an inherently serious matter, both because it involves a subjective intention that is repugnant to the proper conduct of litigation, because of its effect on the efficient administration of the justice system as a whole, in individual cases in particular. The overriding objective itself identifies the need to ensure that cases are dealt with expeditiously and fairly, and the importance of having regard to the resources of the court and the calls of other court users. Further, jurisdiction to strike out the corrupt abuse specifically does not depend on prejudice of the defendant in a particular case. So there's a difference between Judge Kayser and Ms. Justice Richards. I say that Ms. Justice Richards' reasoning is to be preferred. It is the ratio of his decision, Judge Kayser's is obiter. Next case is the decision under appeal, and then the final domestic case is SNV, tab 46 of the bundle. In that case, Her Honour Judge Emma Kelly decided it was not necessary to resolve the issue as to what the test was. We can move straight on to page 676 of the authorities bundle, paragraph 47. Judge moves on to the second stage of the steering test, the element of discretion, exercise of discretion. He paraphrases or summarises the parties' positions and its submissions. We can turn on to page 682, paragraph 69, the double sideline passage. I'll leave the court to read that themselves. Find it not necessary to resolve the issue. I've already highlighted to the court the last few lines of paragraph 69. The modern approach to case management is the antithesis of endorsing abuse of process. In paragraph 70, the judge concludes that whatever the test, whether one applies the compelling reasons or considers what is just and proportionate, I say that's a false distinction. She says it was appropriate for the court to exercise discretion to strike out the case for the reasons given there. And Roman numeral 4, for the first touch hole on page 683, third defendant has had his claim hanging over it for an excess of 5 years. And end the sideline bit in Roman numeral 5, the court's resources are finite and better directed to other cases whose claimants are proactive in pursuing their litigation to conclusion in a manner that accords with the principles of CPR. In conclusion, the claimants in this case abandoned any intention they had to pursue this claim for an unacceptable period of time, such that the point was reached where Grobert-style abuse of process arose. claimant's very belated and half-hearted attempt to re-engage with the claim, unevidenced and falls woefully short of that required to give the court any confidence. They will now put their house in order. In the circumstances, it is appropriate to strike out the claim. Now, a few further submissions. I say, I've touched on this already, proportionality is not a bar to striking out the case. One can see that from several cases, including Mr. Justice Richards in Watford. Even His Honour Judge Kayser in Lloyd touches on it. If I can take you to one further authority, it's at tab 39. It's Altazan, His Honour Judge Pierce. Page 473. Paragraph 16, the sideline passage. I'd like you to read that yourselves.
Sorry, which paragraph?
Paragraph 16, the sideline passage, page 473 of the bundle.
What does that mean, though? I mean, the doctrine of proportionality or
Yes.
a requirement of proportionality clearly applies. The question is whether it's more likely to be satisfied in some cases than in others.
Yes, but what I take from it, and I invite the court to take from it, is the fact that striking out a case does not mean that there is a lack of proportionality.
But it will depend on whether it's proportionate.
Undoubtedly so, but in principle, in principle, it may not be. As to whether it actually is, requires an examination of circumstances under consideration. Of course, I accept that. So I say that the appropriate response in stage 2 of the test is one where there will be strikeout absent compelling reasons. And that doesn't override civil procedure rules, doesn't cut across the overriding objective. It is a sensible and appropriate response given the nature of the abuse, including some unique features which I've highlighted in the cases we've just gone through. The deliberate decision of the claimant, the unilateral decision. Now, compelling reasons is clearly a phrase that's used elsewhere in the civil procedure rules, specifically in CPR Rule 24.3, summary judgment, and in the test of appeal. And in each case, I say it serves a comparable, although obviously slightly different purpose. You have a default position, so in summary judgment you dispose of the claim unless there are compelling reasons. But a permission to appeal, absent reasonable prospect of success, that is an end to it, unless there are compelling reasons. So it starts with a presumption or a default position that provides an exception. And it's inevitably going to be the case that the exception will only operate rarely. That's the very point of having an exception couched in those terms. It will be the rarity where a case which otherwise would be struck out under CPR 24 would nonetheless survive because there are compelling reasons as to why the case or the issue should be disposed of at trial. Similar the position and permission to appeal. In this case, as it happens, Paul Stanley, KC, decided, granted permission on both grounds. First of all, there were reasonable prospects, and secondly, there were compelling reasons that this court should deal with the difference of opinion voiced in the judgments I've shown you.
Those are normal in appeal type
Yes.
cases. It's normally because there's some point which is unresolved on the authorities, or the court.
Yes.
The court thinks that it would be useful for the court to look at it, or something like that. And it's a sort of systemic point about the court's view about the development of the law very often.
Yeah.
that's a rather different sort of
It
set of
is. I mean,
circumstances.
even if one compares summary judgment to permission to appeal, they are different things, but nonetheless, it's the same broad concept of default position with and sort of an auxiliary provision. Now, in terms of permission to appeal, and the White Book commentary deals with this quite well, by submission, it says, well, what is the role for compelling reasons? If there is a dispute of the authorities, well, doesn't that show there is a reasonable prospect of success? Nonetheless, it says that it is a useful safeguard to be used upon, albeit rarely. Now, I'm not saying one applies that automatically onto the structure of this case. It's just simply showing that compelling reasons is a phrase which is known to the legal system, and in my submission is entirely appropriate in this case, given the very nature of what we're dealing with. Bear in mind, and cases have stressed this from as far back as Grovett, an intention not to proceed with the claim does not automatically constitute abuse. It can, but it need not. One has to go into the reasoning and look at the length of it and other factors as well. So it's a higher threshold than might otherwise apply. If the position were that any, let me call it, any warehousing intention was automatically abusive, I would recognise that there would need to be a lower test at stage 2, because many more cases would be found to constitute abuse. You'd then need a more generous catch-all at stage 2. Conversely, here, a lot of the work is done at stage 1, assessing whether there was an abuse. What was the intention of the claimant? The reason behind it, things like that. So a lot of the factors, which in the cases I've touched on, such as Quara Degani and Asturian, that lead the court to conclude that there was no abuse, those are factors which bear quite a lot of weight. So it's more important, or it's more appropriate, to have a stricter test at stage 2. As to the text the judge below himself adopted, one needs to look in a few places. Now, I don't know whether it's most convenient to look at the transcript in the core bundle or the weekly law report, the authorities bundle.
Actually, we have the weekly law report as well.
It certainly says. Penultimate, sorry, I think it might be the pre-penultimate tab in authorities bundle, tab 45. Start off already, page 640, paragraph 6, refers to the overriding objective of 1.1. The courts exist to resolve disputes justly with proportionate cost. Case dealt with extradition value. We know that, but the reason I highlight there is that the judge comes back to that later on. Next passage to look at is paragraph 14, page 644. My judgment then the position is as follows. Two separate questions. First is whether there's been an abuse of process to validate the decision. We can move on. The second question, below C, which arises only once abuse has been found, is discretionary in the full sense. How should the court respond to the abuse that has been identified? Under the CPR, the proper approach to the exercise of that discretion does not depend on compelling reasons, but on the application of the principles that govern the court's exercise of such discretion under the CPR, including proportionality and the overriding objective. The result of the exercise will frequently be that the claim will be struck down, but that is because there will frequently be what the overriding objective requires, not because there is some special test of compelling reasons. And when one turns to the back of the judgment, we'll look at this in more detail shortly, but paragraph 111, which is the judge's assessment, page 662 of the authorities bundle. He concludes that striking out the claim is not the appropriate or just response. Paragraph 111 of the judgment, and we'll turn to why he reached that conclusion in due course. At the moment, I'm just looking at the test. So effectively, the test the judge appears to be adopting is one of justice, having regard to justice and the overriding objective. Now, if that is a synonym for the question of whether a fair trial is still permissible, then that is, in respect, the wrong question. The judge recorded in paragraph 4 that a fair trial was still possible. That's a wrong, if that is what the judge is saying, that's the wrong approach. You can see that as far back as Arbuthnot. The fact that a fair trial is still possible, the fact that there's been no prejudice, those are not determinative issues. So I say that whatever one reads by the interest of justice, the overriding objective, it cannot be a synonym for is a fair trial possible, has prejudice been suffered. That is not the test on any analysis.
I mean, the judge can't have
No.
fallen into that trap.
No.
He's just looked at a whole lot of authorities which
Yes.
say that that's not an answer.
Yes. But he, on some other occasions, as we'll look at, he says some things, then doesn't necessarily follow them. So I'm not positively advocating that he is saying overriding objective is a synonym for fair trial or prejudice. But we'll see that prejudice seems to be the real reason why he didn't strike out the claim. And so that if the test is overriding objective constitutes, is there prejudice suffered? That is, with the greatest respect, the wrong test on any analysis. Whether or not compelling reasons are required. Now, in terms of marrying together, this is developing an argument I've started on, compelling reasons on the one hand with overriding objective on the other, it could be that the authorities say something like the following. Once abuse is made out, the question on the second stage is what is the appropriate response or what is the just order to make? Absent compelling reasons for the abuse, the appropriate or just order is to strike out. Now, I say in reality that is what the courts were saying in Grovett, Chest Hospital, Vitara, and Ms. Justice Richardson, Watford. In other words, the proportionality, the overriding objective is not inconsistent with a compelling reasons test. We're looking at it through the prism of the CPR and asking yourself, given what has happened, given the finding of abuse, are there compelling reasons to let this claim survive? Now, in terms of whether the compelling reasons test is a good test, the judge himself recognises, this is at paragraph 13 of his judgment, bottom page 643. So this is one occasion, we're not looking right place. Strict and inflexible test, bottom page 643, has its attractions. It would be simple to apply and strongly incentivise good practice. And I say that that is a very real merit of a compelling reasons test. It pays proper regards to other court users.
Well, then on that basis, an even better test would be one that didn't even allow a compelling reason to prevent.
But there must be limits. So there needs to be some fallback. Otherwise, that would be intolerable. One can always take things like that to a reductio, my lord. And I'm not arguing that far, but I'm just saying that compelling reasons has the advantage of predictability, has the advantage of avoiding a lot of the inquiry, such as happened in this matter, as to the reasons behind it and the consequences of letting the claim through, etc., etc.
I mean, isn't it just looking at this at quite a bird's eye level from high above? This is really about whether you have a rule which generally applies with possibly rare exceptions, or whether you hand the process over to judges to exercise a discretion taking everything into account, isn't it?
Well, I would
Which is often a tension in law. Do you do that or not?
No, it is. I mean, I wouldn't say it's quite that straightforward for a number of reasons.
Right.
First of all, the judge has to make an evaluative decision either way, whatever you say of those two options. Secondly, those may not be the only options permissible. It may be that even if this court does not find favour with my submissions, that compelling reasons is the test. some midway point stricter than how does the judge
Well,
respond to
by
it? Is it
by
appropriate?
reference to the overriding objective,
Yes.
which is a mandatory requirement on courts.
Yes.
So there's no question that the judge has to apply that. But does one need to go beyond that? And is there a justification for going beyond that?
Yes, I say there is justification because it recognises all the points I made before, the seriousness of the abuse, the frequency with which cases have been struck in the past, and I accept my Lord's point that this isn't a mathematical or empirical exercise. But nonetheless, even if court were to find that compelling reasons were not required, there's still logically a space for something in between that and overriding objective, or what is the just response to the position. One can say, well, what are the reasons not to strike out? They may not have to amount to compelling reasons, although clearly a compelling reason would succeed on whatever the test would be. Absent my Lord Justice Foxton's example of having no fail-safe mechanism. But there is still, I'd say, logical possibility of a sort of middle point where it's not as rule-based as compelling reasons, but nonetheless provides some more onus, some more requirement on the claimant to show why the matter should survive. And the benefits of a compelling reasons test are several. It avoids what has happened here, which is the inquiry into what has happened. It incentivises the parties to avoid bad abuse. In this case, deliberate decision, nearly 4 years of unexplained delay, no compelling reasons given. One of the witness statements on behalf of BlackBerry below even said that BlackBerry has done nothing wrong. That was its stance below. Obviously, the court isn't going to determine this matter in terms of lack of self-acknowledgement commissioned by the party, but nonetheless, it is an important factor. As to what might constitute compelling reasons, clearly that would depend upon the case, any case that arises. It's going to be fact sensitive and will require to look at consideration of all the circumstances. I've said and I repeat that it's in its nature that it would only succeed rarely. I say one shouldn't be beguiled by BlackBerry's silence here and rely on privilege. If they had no good reason for their inaction, then that's an end to it. If they had a good reason but decided not to waive privilege, well, that rests on them. I'm going to contrast that in due course with my client's candour in highlighting the weaknesses it faces from a witness perspective if this matter were to continue.
That's all part of stage one, as it's been described, isn't it? The lack of an explanation leads to the conclusion that they've been abusive for a long time and it's a serious abuse.
It does, yes.
So what might be the compelling reasons other than an explanation of why they delayed, which
Yes.
they haven't got?
No. And
So what would it be though? I mean, what
Well,
sort of feature of the case might amount to a compelling reason?
I've given some thought to this, and one finds no sort of little guidance in the authorities. But bearing in mind that, as I said, it's a valuable reserve power, it needs to have some point. And imagine a situation whereby the claimant's wrongdoing in not pursuing a case is, for potentially a variety of reasons, not something for which they or the current claimant should be responsible. One example might be where there's been a change in the capacity which the claim is brought. Imagine it was brought by a company but not pursued, and then a derivative claim is brought and substituted. The directors may have had their reasons for not wanting to progress the claim, but that might be inappropriate in the right circumstances, deprive the company and shareholders of the benefit of a claim properly brought. There might be other examples, and a lot of these may turn on as a change in the capacity of the claimant if an office holder is appointed. It might be unfair to bar the office holder from bringing a claim just because of the conduct of the company beforehand. There may even be cases, and there's some echoes here with the permission to appeal test, where the case itself has importance which goes beyond the immediate parties. Here we're dealing with a commercial matter of some importance to my client, my own friend's client. Difficult to see its reach beyond that. But as we know, there are lots of types of cases which have a wider impact. It may be that one is dealing with a test case, which would have an impact on other court users. Circumstances like that could provide the opportunity for saying there has been abuse, stage one is engaged and satisfied, but nonetheless, there are compelling reasons as to why the claim might not be struck out. That is all caveated on the basis that every matter will turn on its own circumstances. Perhaps, doubtless encouraged by your lordships, over initial observation, I've made progress more quickly than I was planning to.
Good.
Which will be no bad thing from the court's perspective. If I can just turn to see if there's anything else I want to add before moving on to grounds 2 and following. So, what I've said is on ground 1, and we now move on to the other grounds. Ground 2 is quite similar to ground 1 in terms of it does engage with what the test is. In essence, it's that the judge failed to take into account relevant factors, did not give them sufficient weight. And it really comes down to the weighting or the starting point of the court adopts when abuse has been established. If I can refer you to Mr. Freeman's skeleton argument in this matter, which is in the core bundle. Three. Sorry, I have 2 of them. I apologise. Paragraph 44 and 45, really the heart of the point on ground 2. Even if compelling reasons are not required for a case to be saved, so anything less than compelling reasons might still be relevant. The point is that the judge didn't start from the right starting point.
Which paragraph is that? I'm behind
Paragraph
you.
45 in particular.
Thank you. Yeah.
I'm so sorry, my lord, I cut across.
No, it's my I'm behind you, sorry. Yeah.
Sorry.
Thank you.
You will see what is encapsulated there. One needs to recognise the starting point, which is the seriousness of the abuse found, clearly not challenged here. The natural response is to strike it out. So in essence, I've really done all the work for this ground. Even if you're against me on ground 1, a lot of those factors come into play here. So the judge started at the wrong starting point, and his analysis is thus susceptible to challenge. You have to start from the fact that abuse has been found, clearly, because otherwise you don't engage step 2. I say you have to then think, well, there really needs to be a reason as to why the claim should survive, given that circumstance. You say that even if the test is something other than compelling reasons, the onus should be on the claimant to show why the claim should survive. I'm now going to turn to the, actually before I do that, just to follow through in terms of, because this does a bit of the building work for ground 3 and 4 in particular, looking at why the judge did not strike out the claim. Ultimately, it comes down because he found there was no prejudice to my client. I say that's wrong, and I'll show you shortly why that's wrong. But dealing with the test he adopted and why he made the decision he did.
Well, I mean, he said, as abuses of process go, wasn't up for more.
I missed the
said
last bit.
as abuses of process go, this was not of the more serious kind. So you can't say it's only because there's no prejudice. There's more than one factor at play.
I say prejudice is the primary reason for his. I'll try and make that good. So within the authority fund,
He also took account, didn't he, of the various conditions he could impose.
yes, although those really gave no protection to or very little protection to my client.
And the sleeping dog.
So he did, dealing with the questions one by one, if I may, on terms of the protection, there's the interest point, which I'll come to shortly as one of the specific grounds of appeal. As my Lord Justice Foxton pointed out, the sleeping dogs. Yes, he said, although he said that the failure to acknowledge service had no bearing, he said nonetheless my client was full. And I would say factually and legally that is irrelevant, and I'll come on to that shortly, ground four. So within the judgment, page 89, so paragraph 89 even, weekly law report in on page 658. This is the first real consideration of the question of prejudice. I'm going to have to examine this in more detail when we get onto ground 3. Basically, he finds there was not concrete prejudice in this respect. That's important, and we can move straight forward to paragraph 111, which is his ultimate assessment on the case. And you'll see, bottom page 662, the heading My Assessment. A, no specific identifiable prejudice to Optimus other than in respect of interest. Conversely, prejudice to BlackBerry. I would say that's an irrelevant consideration given the case has made quite clear the fact that a claim is time barred or is not time barred are not factors that operate in terms of whether to strike out.
Is that right? I mean, what there are two different things on there.
Yeah.
Prejudice may not be a requirement of striking out. That's what
Yes.
Profit
Yes.
shows. It doesn't follow that when deciding what to do, prejudice or its absence is irrelevant. That's a different proposition.
Logically, I accept that. However, if one inquires into that, if the absence of prejudice will invariably lead to a situation that there isn't a strikeout, then the whole purpose of creating a new type of Grovic style abuse falls away.
Well, if that's what the judge did, but it might be said about this paragraph that he's saying that he's weighing up a whole lot of factors.
Well,
And one of them is that, but it's not, he's not saying, right, I tick that box, therefore I'm not going to strike out.
Obviously, it's not a tick box exercise, and he goes a number of things, but my submission is that the most important substantial factor appears to be the lack of prejudice to my client. That's in paragraph A. Then there's the other factors, some of which are explanatory and some of them I'll deal with in due course. But what I'm trying to capture at the moment is the real reason why the judge did not strike out the claim. He says it's by a narrow margin he decided not to. So it's a finely balanced, and one can see through the judgment is wrestling with certain things such as prejudice in relation to witnesses, etc., etc. My point here, and perhaps I'm labouring unnecessarily, is that really it's the prejudice or the lack of prejudice to my client that's the primary reason why he didn't strike out the claim. What I propose to do now is deal with the remaining grounds of appeal, and I'll take them in this order. I'm going to deal with ground 4A and 4B next, because they're also failure to have regard to relevant factors, having regard to impermissible factors. So logically, by submission, they follow on from what we've just been discussing. Then we'll look at the most granular, which is ground 3, the prejudice. And I'll focus particularly on witnesses, and then look at some of the others, such as interest and the restating of accounts. I'm not pursuing ground 5. ground 6 is a perversity, and ultimately it stands or falls with your assessment on ground 3 in particular. I say, however one categorises the judge's findings, they cannot survive. It doesn't matter very much. And finally, in terms of ground 7, perhaps I can deal with that now, just to dispose of it. That's turning back to the strikeout. So on the premise that I failed to persuade the court that compelling reasons is the test, or the matter should otherwise be struck out, I have a third bite of the cherry in saying, well, actually, quite apart from the strikeout, the judge was wrong to have lifted the stay. Now, logically, it is possible for the court to be against me on the first 2, but to be with me on the final point. But the reality is, it's very difficult to see how that would be.
So it's a stands or falls point.
Effectively, yes. Yes.
All right.
So what that means is that we're now left with grounds 4A and 4B and then grounds 3. And on this basis, I should finish my lunch.
Thank you very much indeed.
So ground 4, 2 parts to this. Ground 4A is the failure to have regard to third-party court users. Now, for your note, this is in paragraph 64 of the skeleton in the core bundle. I don't need to take you to that because I can deal with it quite quickly. It's clear, we've seen a number of cases so far, where the court has regard to not just the litigants in this case, but other litigants.
That's the whole purpose of the CPR, isn't it?
Exactly. And that doesn't appear to have been a fact which the judge gave any consideration. My lord is
I find the suggestion that Mr. Stanley Casey was not aware of that an improbable one. He does at 111C make the point that the stress cases lay on diligent pursuit of litigation, the significance of sanctions deterring abuse, overriding objective not being concerned just with the fair trial. And we can't make these tick box exercises for first instance judges where if you don't mention some frankly bleeding obvious point, then there's a route through to the Court of Appeal on your discretion.
No, and I'm not seeking to do that, my lord, but it's taking stages to say, first of all, clearly, my lord Baker just said that that's the whole point of the CPR, to have regard to all those things. A lot of the other cases, it's something which is credit is expressly given to in the weighing up of the decision. I acknowledge that some things can be implicit in a judgment, but I would say that one doesn't really see that this point is given any great weight to here. I'm not sure if he was my lord's pupil or not.
Not my pupil, we were in chambers.
Right, I of course know that, yes, to him. Turning then to ground 4B, this is criticisms of Optimus's conduct, the sleeping dogs. But the judge clearly had regard to my client's conduct. And I say that that's both factually and legally irrelevant. Now, I already acknowledged CPR Rule 1.3, the duty to help the court. We've already debated Asian Sky and the fact that, contrary to Burkett and James, it's no longer appropriate to let sleeping dogs lie. However, we look at how the judge analyses my client's conduct. Paragraph 83 of the judgment where he deals with the failure to acknowledge service. In some 10 lines down or so within paragraph 83, the judge says, but the failure to acknowledge service did not matter much for BlackBerry. Its only direct consequence was to require the application for summary judgment, to include an application that be permitted to be made before acknowledgement had been filed. It was a minor routine point. So any failure on that front, in respect, goes nowhere. We then have to move on to paragraph 85. On the other hand, the broader point that Optimus, no less than BlackBerry, had the means and the responsibility to progress the case remains relevant. So is the fact that Optimus simply did not engage with the case formally or informally. Attitude was one of wholesale disregard of procedure. Quotation we've seen before from Justice Clark in Asian Sky. Now, I say that is contrary to cases going back to Arbuthnot, which say that in a case like this, where it's abuse of process, a unilateral decision by the claimant not to pursue a claim, the defendant's conduct doesn't really come into it. We can go back to Arbuthnot tab 26.
You take issue with the general proposition that under the CPR, defendants can no longer just say, I'm going to let sleeping dog lie.
No, of course I acknowledge the general proposition. What I'm trying to establish is that because of the specifics of Grover's style of use, an internal decision by the claimant, it's quite difficult to see why the defendant should be criticised for not interrogating that decision-making process, and there's a number of authorities to that effect. So back to Arbuthnot, tab 26, page 221, sideline passage at the bottom left of page. The conduct of the defendant may also have been released. However, this is not a matter upon which the plaintiff can rely when there has been an abuse of process. The counterclaim has been correctly struck out as well. And that is followed in at least two cases, Alphosen and Watford. I'll deal with them quickly. First of all, Alphosen, tab 39. Page 473. Paragraph.
Sorry, just say that again. Which tab is it?
39.
Tab
Thank you.
39, I apologise.
No, it's my fault. I'm just making a note. Yeah.
Bundle page 473, paragraph 16. So Judge Pierce starts dealing with the availability of alternative powers can only be with one factor. Would be inconsistent with the overriding objective 5 lines down to disregard the diversion of resources that arises when the court needs to investigate the party's procedural failings. In particular, if the evidence suggests a continuing reluctance by that party to comply with the norms of litigation. I accept that the power to strike out is a long-stop jurisdiction, only to be invoked where other powers appear insufficient to achieve the purpose of progressing the claim. But where the court is satisfied that a claimant has no intention at all to progress the litigation, I would not see the doctrine of proportionality or the need to consider alternative, less draconian orders first as necessarily a bar to striking out the claim.
Is that on this particular point of sleeping dogs? How does that play into?
Well, it's asking the question.
I mean, he seems to go on to sleeping
Yeah.
dogs in the next paragraph.
Yes. Then he moves on, paragraph 17, to sleeping dogs. Leading on to it.
But isn't he making what appears to be the valid point? That
Yes.
the question of abuse, conduct of the other party, is not relevant, but the question of response or sanction, conduct of the other party may be relevant.
Well, I'm going to come to the paragraph that really makes the point I'm thinking. Now, it's page 486. Paragraph 39, and what I've said is by way of context for this. As the relevance of the second defendant, page 486, bundle, paragraph 39, as to the relevance of the second defendant not having applied for a case management conference, the claimant's point is little weight. If the claimant is in fact guilty of warehousing a claim, it is difficult to see that it is incumbent on the second defendant to incur cost so as to try to force the claimant to change its approach, at risk of the court failing to act on the claimant's abuse of the process. And so that's the position in a nutshell. Unlike other cases, if there's a non-compliance with order, you can say, well, it's 6 of one, half a dozen of the other. Here is different.
What is the difference? Just sorry, speaking for myself.
Well, the difference is because the nature of the abuse is in its unilateral internal decision
Yes.
of the claimant.
Yeah.
In cases where nothing has happened for several years, the party may infer that there's no intention of pursuing the claim. So what this case asks, and other things as well, is, well, why should the defendant seek to jump the gun and try and establish what the claimant's doing? Why can't it just apply to strike out the claim as an abuse of process? And to similar effect in Watford, Justice Miles makes, sorry, Justice Richards makes the point that, and I've taken you to this already, so I won't do it again, that Mr. Brown, the defendant in that case, had no control over whether the claimant formed the requisite intention. The principals in Asian Sky are not engaged.
Which paragraph?
And that's paragraph 57. I've looked already. Bottom page 619. 20. No, sorry, that's. I'm just giving you a reference to Lloyd.
Are you looking for
Yeah.
Watford?
No, that was right, I think.
Yes, no, so yeah. I gave you the right reference. I unfortunately turned to the wrong page, which is why I was slightly blindsided by what I was
Yeah,
reading.
no, that does seem to be.
I have given you the correct reference. I
Yeah.
apologise. So, I say in short, while I acknowledge the responsibility of the defendant to comply with the CPR and to ensure that the case has progressed, I say there is a difference between the Grovett style abuse on the one hand and other non-compliance with orders, given the focus on the claimant's decision-making process. The next question: why should the defendant incur the cost in divining the claimant's approach and its real and intentions and reasons?
And you can see a case possibly where, conversely, the defendant has tried to get things moving along and has written letters and said, why are you not doing anything, so on. When you might think that the case for striking out is a whole lot better. So it would seem to be a potentially a powerful factor in favour of striking out in some cases.
Well, undoubtedly, in the right case, if my clients had done that here, it would make the matter even stronger. The concern is, well, at what point does it become appropriate for the defendant to make that question? Is it 6 months? Is it 12 months? We get into the mathematical issues again. Are they in danger in jumping the gun in asking those questions? If you take a certain amount of time, such as 4 years here, you might think, well, the risk of it is pretty slim.
But it shows that the conduct of the defendant might actually be a relevant factor. It might be a powerful, as I say, it might be a reason to strike out, or another reason to
Well,
strike out.
you could even rely upon that without having to shift the focus onto the conduct of the defendant. You can say, well, in terms of looking at the claimant's lack of interest in pursuing the claim, the defendant even wrote to the claimant to say, well, what are you planning to do? And they were silent. And you can look at that through the prism of the claimant's inaction rather than the defendant's conduct.
All right.
So I think that is the argument for B, having regard to the defendant's conduct. I say that is wrong and was an impermissible factor. That just leaves the granular ground 3.
What about 4C?
Not.
Not pursuing. Thank you.
Various grounds again. I'm going to start with 3A, witnesses, which I say is the most obvious example of prejudice. Now, what I say is without prejudice to my client's main position, which is that prejudice is not a relevant factor. And part of this explanation showing what my client has to do highlights my submission why compelling reasons is an appropriate factor, because it avoids these very kind of inquiries. a self-evident proposition that a passage of time can lead to prejudice in terms of one's witnesses, employees, and leaving the party to the litigation. My point is, in summary, as follows. Contrary to what the judge found, my client did suffer clear prejudice in that of the three most important potential witnesses, one died during the period of BlackBerry's abuse, and two ceased employment during that period. Had BlackBerry pursued the claim in September 2020 onwards, I'd say my client could and would have taken steps to prove them, to enter into terms with the individuals when they left, that they would cooperate with my client going forwards. Paragraph 88, we've touched on this already in the judgment. Tab 45, the authorities bundle. This is the crucial part of the judgment. The BlackBerry's response to these points relies on several strands. It notes some relevant personnel, Mr. Nitesh Gupta, who remains a director, Mr. Ashok Gupta, who remains as chairman, are still available, and that Optiemus is still in contact with a consultant, Mr. Mahendra Bothra, who was the project manager. Now that's said to be BlackBerry's answer. In fact, it comes from my client's evidence, and it's a partial, in the greatest respect, misleading account of the evidence before the judge.
I don't think the judge is saying that was in BlackBerry's evidence, is it?
Yes, it's. Well, I'll see to you it's not.
No, nobody's
Yes.
saying it notes that. I mean, that could be
Yeah, there could have been a submission, but
a submission based on your own evidence.
yes. But ultimately, what it comes down to is the evidence, and I say that the evidence does not support that conclusion. Now, by way of the court's understanding of the evidence before it, the first witness.
That's not actually a ground of appeal, is it?
Well, the ground of appeal is that the judge wrongly held that there was no prejudice.
Well,
related
it's
to the witnesses.
the ground of appeal is to do with other people. Mr. Bhatia, Mr. Agarwal, and Mr. Kumar.
Yes, but it's all tied up. What I want to say is that these three people had very little evidence to give, so the judge can't rely upon their continued involvement as having anything to do with the situation.
Right, but this is one of the features of an appeal where you're trying to go behind the judge's findings of fact. You'd normally be expected to identify exactly which points you say are wrong.
Yeah.
And you have identified in your grounds of appeal these other three witnesses, but you haven't identified this point about Mr. Gupta, the two Mr. Guptas, and Mr. Bothra.
No, and I didn't draft the grounds of appeal. Obviously, I'm responsible for them as presenting the matter to the court. I just simply know that way of background. My point is that paragraph 88, where the judge relies upon those three individuals as being still available and able to give relevant evidence, which means that the departure of others is not a relevant prejudice, is wrong. Because the other three individuals have clearly left, two left, one died. These three individuals, contrary to what paragraph 88 says, have no real evidence to give on the matter. That's my point.
I should know the answer to that, but do we know what sort of issues were going to be in play in the trial? Was there some outline so that you could test, well, is oral evidence going to be of particular importance?
Well, ultimately, so this is a license between BlackBerry and Optiemus. Optiemus were complaining that BlackBerry had delivered or provided certain deliverables late and in an non-compliant way. So it comes down to technical assessments. And a lot of that is going to turn on the client's witness's explanation of whether what was provided worked or didn't work or was delivered late. And so that this is an area where witness evidence is material.
So the complaint is effectively late and defective.
Yes, late and defective. That's sufficient for present purposes. My social evidence. We're not talking about a construction of a contract on which witness evidence is going to have peripheral any importance. Now, in terms of the evidence before the judge, the first witness statement on behalf of BlackBerry in support of the lifting and stay, Mr. Murtha, said nothing about witnesses because it was before the application strike had happened, so we can ignore that. The first witness statement from Mr. Rabinovitz, who sits beside me, is relevant. He notes the number of employees he was there. I'll take you to that. So this is in supplemental bundle. It's really supplemental bundle, tab 5, page 50. And at page 50, bottom of 49 onwards, Mr. Rabinovitz mentions Mr. Bothra, consultant. Says Mr. Bothra does not have access to any documents. His role was as a project manager. This is the top of page 50, Roman numeral 2. Not on top of the detail. 54.2, Mr. Nitesh Gupta, Director. Primary source of information still available to Optimus. So much of this, or some of Mr. Rabinovitz's statement is I am instructed or informed by Mr. Gupta. However, the nature of his involvement was to facilitate Mr. Bothra's role, ensuring that Mr. Bothra, a consultant, was receiving what he needed from Optimus to fulfill his role. 64.3, Mr. Bhatia died. 54.4, Mr. Ashok Gupta, the chairman of Optimus, remains Optimus, important in managing the relationship, involved in managing crisis and issues. Last two lines, does not and did not have knowledge of the day-to-day progress of the project or the detail of the software issues. 55, conclusion, as a result, Optimus only has available to it a limited number of individuals with any contemporaneous knowledge of the BlackBerry project. Nitesh Gupta, Ashok Gupta, and to a limited extent Mr. Mahendra Bothra. Those individuals are not the individuals who would have been expected to give the main instructions in relation to the defence of the claim, as they do not have the detailed day-to-day knowledge in respect to the software development. It is key to this dispute. Now, no subsequent statements, even those from Optimus, deal with the evidence at all. So this is the material, and that material is encapsulated in my client's skeleton below. One can see that tab 30 of this bundle.
I don't really understand the criticism at this point based on those people, because the judge says in 87 that according to the evidence, most of those who have most deeply involved have left. The only remaining employee was part of a legal team, and his role does not appear likely central to the case. And then he records that these three people are still there, but he's not saying, but that's the answer because they've got loads of good memories.
But it leads in, you have to read 87 through to 89. 89, the evidence does not support the proposition that BlackBerry's delay caused concrete prejudice in respect.
What do you say about the second half of 88, after most of the employees who left and etc.?
Okay, so BlackBerry is saying, the pre-action correspondence in 2019, essentially it says that any prejudice in respect cannot significantly be attributed to any delay for which BlackBerry might be criticised. Most of the employees who left, and notably those who left on bad terms, were made redundant shortly before the pandemic and therefore sometime before any decision for which BlackBerry could be criticised. The employee who died in 2021 would have been unlikely to have been thoroughly proofed before his death, even if the proceedings had advanced quickly. Now, taking this in stages, yes, a lot of employees had left before the period of abuse. So BlackBerry can't be held responsible for their departure, but that is the context for the subsequent departure of the 3 individuals, 1 who died and 2 who left during the period of abuse. It makes it all the more important and critical for my client, because they go to a situation whereby in 2020 there are 3 individuals who have potential relevant evidence to give, but they leave, die during the period of abuse. Had BlackBerry issued its application for summary judgment in September 2020, my client would respond differently and had the opportunity to prove those individuals, enter into terms with the 2 departing individuals to ensure their cooperation. It didn't. And the final part of this is the individuals identified in paragraph 88, who the judge relies upon. Well, they're still there, so it doesn't matter in a way, or it matters less that other people have gone, because those 3 are still there. So say one looks at the statement of Mr. Rabinovitz I just showed you, they had very little to say on the technical side. His conclusion, 89, the evidence does not support the proposition that BlackBerry's delay caused concrete prejudice in respect. That respect is simply unsustainable. It did, when one analyses the various staging posts. The loss of people before the abuse, that's simply the context for what happened during the abuse. It's the loss stroke death of 3 people during the abuse that is the critical thing. Those who remain are no replacement or substitute in terms of witnesses. As I say, there was concrete prejudice in relation to the witnesses. That's ground 3A and really 3B as well, which is the sort of passage of time and the importance. And grounds and the skeleton say, well, this point about this was never going to be the case that turned on witness evidence wasn't put to the parties. Given the nature of the dispute, the exchange I had with my Lord Justice Foxton, witness evidence was pertinent. So it's not right to say you can sideline the witness evidence in a case of this nature. So that's 3A and 3B. On to ground 3C, the need to restate the accounts. This appears in the judgment, paragraphs 97 to 101. Very simply, provision was made in my client's accounts for this claim, the 2019 accounts and the 2020 accounts, but not in the 2021 accounts. And I'll show you that shortly. Contrary to what the judge says, there was undisputed evidence that the reason it ceased to appear in the accounts was the non-progression of the claim. My client has suffered prejudice by, assuming this claim is not struck out, having to make a re-provision in the forthcoming accounts. That is a prejudice of itself. It also undermines the credibility of the directors in the eyes of shareholders. My client is a publicly listed Indian company. Might even destabilise the business, the change in the share price. Asking the questions, well, why didn't you continue to make provision for this claim? In the SNV case, Her Honour Judge Emma Kelly found, and I'll take this if it helps, she found compelling the ongoing risk of reputational damage to a publicly listed third defendant in that case. Perhaps I can just give you the bundle reference. It's Authority, tab 46, page 683, paragraph 70, Roman numeral 4. Now, that's in her case. This case needs to look on its own fact. It's a potentially relevant factor. And it's clear that Optiemus is a public listed company and the judge himself records that. So there's no issue with that. So all that needs to do in terms of the documentation is take you as quickly as I can to the accounts and Mr. Rabinowitz's witness account. This is all within the supplemental bundle. First of all, tab 11. (2019) accounts. Turn over the page to page 159. Paragraph 33, reference to agreement with BlackBerry. demand of 4.29 US million. Moving on, tab 21.
Do we need to look at these? Because the judge records
Yes,
this, doesn't
no,
he?
I'm so
He
yes,
goes through
yes.
the history and then sets it out, I think.
what respectfully agree, my lord.
Yep.
What you do need to see is the evidence in relation to that. That's
Yep.
tab 5. Mr. Rabinowitz's witness statement, page 38. Page 52. Paragraph 63, straddling bottom page 52 to top of 53, 63.2, crucial bit. Following BlackBerry's failure to pursue the claim was removed from the notes to the financial statements and balance sheet for the year 2020 to 2021. Informed by Nitesh Gupta that this decision was taken because Optiemus did not hear further from BlackBerry in pursuit of the claim and therefore considered it to be at an end. So contrary to what the judge says, there was clear and undisputed evidence as to the thinking behind my client's removal from the accounts.
Where do you say that the judge was wrong on this?
Is it the insufficiently clear part, or the?
I'm sorry, I missed certainly the second question, but the first one.
Sorry,
Yeah, we're just looking to see
yes,
where,
101.
is it 101 or in the judgment? Where do you say the judge got this wrong?
Yes, it's yes, it's 101, 3 lines down. What management judgment went into a decision to disclose the dispute, but to remove the note the following year is insufficiently clear. And I say it is clear from the evidence I just showed you. That's ground 3C. Ground 3D is the loss of the ability to terminate the contract. Now, this is paragraph 104, where the judge declines, it's under the heading summary pursuit. The judge declined to consider this point. I say with respect, he misunderstood the argument. What this was my client saying, had we known in advance that BlackBerry was going to resurrect the claim, we would have taken the opportunity to unequivocally terminate the contract, such that subsequent license payments would not have been payable. That's without prejudice to their argument that the agreement was terminated in any event. But it's the belts and braces argument. And they say that not being aware that BlackBerry were going to revive the claim and then amend it considerably has deprived of the ability.
A contractual termination provision or for breach?
I understand certainly for breach and potentially for contractual provision. Now,
BlackBerry never said to them, don't worry, we're giving up on this contract. This is all based on an inference from the fact that the proceedings weren't going ahead.
the proceedings weren't going ahead, no further invoices rendered at the time, as had been previously. Silence from BlackBerry's front.
But your clients could have served this notice, is that right?
It could have served,
That's
but
its case.
But yes, it could have said it thought there was no need to, given that this had all gone away, wasn't being pursued. Now, my client wasn't asking the judge to determine the substantive merits of the claim. It's simply that there was prejudice in that another string to its bow has been deprived of another string to its bow in not being put on notice that this claim was going to be pursued and it would have terminated unequivocally.
And was this in evidence at this point, or is this a submission? In other words, was this raised as a further form of prejudice?
Well, this was certainly another point of prejudice.
But in the evidence?
Bear with me for a second, I'll just check that. Actually, if I can come back to that at the end,
Right.
probably the best use of time. And finally, ground 3E, prejudice in the form of interest. Now, the judge here did recognise there was prejudice, and it is accounted partially in his order, but only partially. And in fact, we can understand sufficiently what happens from the order itself, which is in the core bundle. Tab 6. Page 75, the final recital even, or the second control, and upon the claimant undertaking not to seek an award of interest for the period 1st September 2020 to 18th July 2024 inclusive, in respect to the principal amounts claimed in the original claim, 6.4 odd million US dollars. So there's an undertaking in relation to the original claim. However, as the court will appreciate, I hope, the claim was amended substantially. So it's now the sum sought. One can see this tab 12, this bundle, the amended particulars of claim. Page 125, the core bundle. Sum of 6.493 million struck through for 22.516 million US dollars. No comparable provision has been made in relation to that. The prejudice has been suffered.
When were the invoices submitted that were subject to the amendments?
I can't give you the date immediately. I can check that.
Oh, that's very detailed.
I can answer that if helpful.
Sorry, I can't.
Well, I'm so sorry.
No, it's not. Hang on. Give me a second.
Maybe switched off. Just as a matter of fact, our primary position is there was no need for an invoice under the contract. There's clauses that support that. The invoices that were issued contingently in case we were wrong on that in the autumn of last year, except for one invoice that it was issued actually in September 2020. That raises a factual point that cuts across my learned friend's submissions. I'll save that for my own submissions.
So, what my learned friend says, that's the my client's argument in relation to this. There was prejudice suffered. The judge only made a partial provision for it. And removing or ring fencing a very small, and what is now a very small amount of the claim from interest is not really much of a ring fencing in the overall scheme of things. My lord, subject to checking the reference for the evidence, we really have got to the end of my submissions. Again, subject to any
Sorry, I'm
further
really sorry to interrupt. The audio's not working. Could you speak again into that mic for me?
Certainly, is that working?
I can't tell until you speak. I'm really sorry. I don't understand these volumes.
Is that picking up now?
Can you keep speaking, please?
My lord, what I'm about to say, subject to intervention, will take a minute. I suspect the court's keen for me to continue.
Yes. This was in relation to the whether there's evidence or not.
Yes, so the reference I've been given, it's in the supplemental bundle.
Yep.
Page 112, whatever tab that is, maybe tab 7. So this is the second statement of Mr. Benedict's, 812 paragraphs 56 to 57. That's the evidence there supporting the point. And it's the last few lines, thank you, each one of my lords has found the point, the last 3 lines of paragraph 56. Optiemus will, I'm informed, have sent an unequivocal termination notice without prejudice to the position. The contract was already terminated. So with apologies for the delay, that is the evidence. So I'm not pursuing ground 5. The other points have really been covered already, subject to what I'm allowed to say by way of reply.
Yep, well, you've been extremely succinct and very helpful. Thank you very much indeed. Thanks, very kind.
Would it be sensible for me to start, or shall we recommence perhaps slightly early?
Start early. Rise and start early.
Yes.
I think we'll rise and start early. Yeah, I think we'll rise and start early. We'll start again at 10 to.
Thank you, my lord.
Thank you very much.
All rise in favour.
A few hours later. I think there's actually some merit in being compelled to cut points on a case like this, because
Doesn't always work. But
there's too many highways and byways.
thank you for your assistance on the last one.
Oh no, don't worry. No, it's actually quite confusing the way it developed. But I do have a standard point to make. But I didn't want to interrupt you by making it.
I think I've worked out what it is.
Well, that was quite good. We may still never not been screwed. Quite good for the finish today. Very, I know. I was about to say, if this pops open, Morrison correspondents are obviously superior in quality to mine, because I have endless issues with my bundles going ding and then things flying out. You may remember that happened actually at the previous hearing. I opened it half the contents before that. But yours survived. So that's good. This is my friend Imogen. She's a New Zealand solicitor. She's
Yes,
come along to watch. I mentioned the case was exciting. So I hope the afternoon's good. I understand you may agree when you're from Dublin, because he's my pupil this term. So I keep singing your praises.
Yeah.
Imogen, can we grab some lunch and we'll be back?
Only if you've come.
Yeah, well, for you, because we're not
Yeah,
going to. I'd love to get lunch with you.
No, I don't.
I need to do an audio test with the
Are they
text.
able to come back?
Well, I'm asking them.
Because I'll
to.
open up anyway.
I won't even leave this desk. I really need to do. Can you just tell me who's sitting where on the bench again, please?
In the middle, you've got
You said
Jeremy Baker.
So who's him? Miles.
that's Miles, and then on the other end you've got Foxton. I really need to look up now.
I know, I just have to send these messages.